welcome to our panel on the evolution of data sharing in a complex world. There's a few people still filtering in, but I think we should probably make a start. We have an hour and 15 minutes for the discussion, but quite a lot of ground to cover. I'm James Arroyo. I'm the director of the Ditchley Foundation, which you may or may not have heard of. We don't publicize what we do particularly. Ditchley works for the renewal and strengthening of democratic societies, states, and alliances. We mean everything and how that fits together. So everything from society through to hard defense, because the two are obviously interdependent. Just a word on what we mean by a complex world. You know, why we're talking about the evolution of data sharing in a complex world. The world is getting complex and interesting in different ways. The first angle is that we're building capabilities on which we increasingly rely, which need access to data to make them work well, and often access to data internationally. So there's a tension between the capabilities we want and that we're getting used to having and purely sovereign control of data flows within borders. And that's a complex tension in itself. The other way the world is getting complex is that it's frankly getting less peaceful. There is obviously the war unfolding in Ukraine, which has another angle, and we'll get onto that in Europe. But there's growing tension as well in the Indo-Pacific. And a lot of, I've literally just come from Washington, and a lot of that tension is being played out through technology, through data in particular. So those forms of complexity are interacting. We've got a great group of people today, and I'll turn to them each in turn rather than introducing them all at once. And what we're going to do is we're going to have each person lead on a particular question. But what I also want to just put you on notice is that I want to turn to you at various points during the discussion rather than just have you passively sit, listen, and get to a few questions at the end. So please be prepared to ask questions. Please be prepared to be questioned and to come back to us so we can make this as much of a conversation as we can, as much of a genuine discussion as we can in the context of a large echoey hall with a microphone or microphones. There is a microphone for the audience as well, and we'll try and get that to move as quickly as we can, please. So again, we can get the conversation going. Right, let's kick off. And I want to turn first of all to Julie Brill, who is organizing this panel at Microsoft. Julie is Microsoft's Chief Privacy Officer, amongst other things. She has many hats. Julie, I mean, from the perspective of a major tech platform like Microsoft, what does this world that is emerging mean for the management of data access, for data flows, particularly across borders, but also more broadly? I mean, you know, what's the right balance and how do we strike it between privacy on the individual level, for example, and public safety for societies and for things that we also want data to do?
Well, thank you, James, and thank you to the CPDP committee for having this discussion. We do have a great group. They'll all be introduced as they start to speak. But I'm honored to be able to kick this off. You know, GDPR, which sort of didn't really invent privacy regulation. Privacy regulation obviously existed with respect to the directive and in many US laws that are more vertical and granular. But GDPR really, I think, set the tone for the need to ensure that there is privacy protection, but also the free flow of data. It's right in the title of the General Data Protection Regulation and ensuring that there is free flow of data. And I think what we are learning now is, of course, those are two key fundamental values. Obviously, protecting data, protecting privacy is as important as it ever has been. Ensuring the free flow of data is also very important continues to be for economic benefits, and also to use data for additional purposes that we are starting to uncover and helping to advance society as well. And as you said, James, at the same time, we're facing a lot of desire to further restrict data. It's not dissimilar from some of the things that we're seeing in the world of trade. There are more restrictions being imposed around trade than we have seen lately. But with respect to data, it's not just about economic issues, but it really is about security issues. So I'll talk about that in a second. So in some ways, what I see is there's a rising tension that we're seeing in terms of needing to use data for more purposes, including flowing around the world, and the need to, in appropriate circumstances, restrict where data is flowing. So in terms of the need to use it, we've mentioned economic development. That's incredibly important. Protecting safety. Crime is global now, and the fingerprints for bad actors who are engaged in ransomware, child exploitation, child trafficking, horrible drug and gun sales, and various other violations of all sorts of laws. The fingerprints to find individuals who are perpetrating these crimes is digital. And the crimes are not happening, they're not honoring national borders. These crimes are global, and often the perpetrators, when it comes to child abuse, sexual abuse of children, will often be taking place outside of Europe, outside of the United States, often in other countries. We need to have digital fingerprints in order to be able to keep children safe, to keep individuals who are victims of crime safe. So this is something that I think we're seeing more of in terms of the needs for using data more globally and having data flows for the purpose of public safety. I think another issue that we really need to be focused on in terms of using data more immersively and more sort of in a more nuanced way than currently is happening on both sides of the Atlantic is generally to protect children, not just with respect to global crimes, but to keep children safe when they're online. We need to get better at things like age detection. We need to get better at using data to protect kids. And at the same time, we need to ensure privacy. So that is a really interesting area where policymakers still haven't really resolved this. How do we use data to ensure that kids are seeing appropriate things online, are engaging in appropriate ways with people they should be engaging with, and they're not being groomed and engaging in other conversations that are really going to harm them at some point, usually pretty soon. I think you mentioned, you were alluding to AI. You didn't actually mention AI, but clearly the use of AI in order to solve health issues, to solve sustainability issues and environmental issues is only going to grow. And frankly, it's going to be most powerful when we have individual information in order to target solutions for individual needs. So that's kind of what we're seeing on the need to flow. I'd say quickly in terms of the need to restrict, we're seeing a rise in the United States, not just what we would call sort of adequacy decisions, what you are seeing, for instance, under the Cloud Act or under the Cloud Act agreements, where the United States will allow law enforcement to have information if those jurisdictions have appropriate levels of protection for lawful access. But we're also now seeing laws and rules being developed around data flowing to particular nations for national security reasons. The US has adopted some laws around this, around bulk data flows going to certain jurisdictions, Russia, China, et cetera. We're going to, I think, see more laws that are going to develop around these geopolitical issues, which are also national security issues, which I think I'm not worried that we're going to have a splinter net, that we will have no data flows, but there will be a much different approach, I think, to data flows in the coming years as some of these other laws around national security and around geopolitical issues start to flourish.
Thanks, Julie. Anna, Locke, Nico, any comments on that before we go on to Anna's question? I mean, just to sort of, what does that balance look like to you? Locke, why don't you go ahead, and then we'll turn to Anna.
Well, I wrote some articles, the transatlantic data flows, it's the geopolitics stupid. There's a limit to what GDPR can do. Yeah. A simple example is if enough people give consent for analytics of their DNA to a Chinese company, that can be, the results can be extrapolated to the entire population. So maybe it's totally valid under GDPR, but GDPR protects individual privacy, but not our collective data. So I'm totally with Julie in the sense that Europe always wants to have a fit-for-all solution, so you do not have to pick and choose and declare who your enemy is. But sometimes GDPR doesn't work enough and you need to differentiate. And I think in that sense, what the US and Biden with the executive orders is doing with transfers, sensitive data transfers to China, which China itself is doing exactly in the reverse, is something we cannot get around. GDPR gets us so far, but not everywhere. So I've a lot more to say on it, but this is a comment.
Thank you very much. Okay, I said I was going to come to you. I have a question for you, and I want people to raise their hands, and then we'll see if there's a comment. Who feels that they're in a society at war at present?
Sorry?
A society at war.
Well, I would love to make a comment.
Who feels that's...
No.
So one tentative hand. Yes, one hand. Could you explain why you feel we're in a society at war?
Hi, thank you. This is Shukun Tokas from Sintef Digital, Norway. We are researching on uninformed consent, as in when people resign from privacy at large. So what are the repercussions? So you see a more polarized society. You see what's happening with kids, as it was mentioned by Yuli. So there is trading of data at such a large scale, which the consumer don't really understand. Just by giving the uninformed consent, we bypass all the protections GDPR and other regulations gives us. And then that data is being sold and bought, and then based on that, we receive content, advertisements, recommendation of products on our everyday applications, smartphones, whatever we use. And we are shaped by what is recommended to us. And largely, the society is in problem because the negativity sells more on these platforms, which affects, yeah.
Great. Okay, well, that's an interesting answer to my question because it shows tensions in society. But I actually meant, at war with another country as well. And I didn't expect many people to feel that in this context, but I think it's going to get interesting and complex because large parts of Europe, Poland, for example, does feel that they're very close to that. And that's going to start to have an impact within Europe as well as the broader context. Let's go with the theme of Europe and turn to Anna Buchter. And Anna is head of the Policy and Consultation Unit at the European Data Protection Supervisor. Anna, I mean, would you comment on the layering of legislation that's coming through? There's a lot come through. How do you think it's going to sort of play out as the different acts build on the other? And are we going to see some contradictions, or do you think it can be turned into a coherent whole?
Thank you. And first of all, thank you for having me here. It's always a pleasure to be at the CPDP conference, even if this is a new venue. I guess you mean mainly the different regulations that touch also data transfers, international data flows, yes, matters of national security, and not necessarily the multiple layers that we now have in the EU with the various acts.
Don't try and do everything.
Exactly, the alphabet soup. So I will focus on the first group. Maybe first to explain why does the EU feel we need all those different rules? While I think at the time of negotiations and adoption of the GDPR, there were great hopes that it will solve great many issues and take care of all conceivable problems in the field of personal data processing, it has obvious limitations of scope, for example, linked to the scope of EU law itself. So it's difficult to expect the GDPR to properly address challenges related to national security, for example. We will inevitably need other frameworks. Same for law enforcement. Even for that, it was decided to already at the start have a separate instrument. And then, of course, as Julie rightly explained, there is underneath those different processes that she described, there are inherent conflicts between the different values, sometimes between different fundamental rights, different interests, not only between conflicting visions of society, let's say democratic nations or not so democratic nations and different geopolitical blocs, but even within societies. And sometimes those different interests can reinforce each other. So, for example, encryption or end-to-end encryption can be a very important safeguard for privacy, for data protection, for security and safety, but sometimes it can be impediment for legitimate investigations by authorities. So to resolve all these different tensions, inevitably we stumble, I believe, from one set of regulations to another. And all of that, to my mind, is almost an unavoidable result of the importance or crucial and growing importance of data flows, including personal data, for today's societies, not just the economy, but overall the functioning of societies. And for a long time, I had the impression we had maybe collectively quite a naive notion that data will just flow. It's the new oil, so it will flow, it will be everywhere. I always hated this analogy, by the way, but even if you think about oil, obviously, it's very regulated. It's a crucial, scarce resource, and it never was just traded without any rules, cartels, and restrictions. And it's a little bit of the same that I think we see with data nowadays. So globalization plus the geopolitical tensions, sometimes open conflicts, I think drove home the message that in order to safeguard data flows and safeguard all the interests that they serve, we need trust. And we also need to agree what that trust means and how to operationalize it. And I see those different frameworks as an attempt to define what do we mean by trust and how do we make it operational.
Thank you, Anna. That's really interesting answer. Does that mean that the role of and other people come on this as well, that the answer is expanding the EU's competencies further as data becomes ever more important for all aspects of life?
As a convicted European in an ideal world, yes, I believe we do not have enough cooperation in those matters that touch specifically security or national security. I think Nico might have more to say about that. But I don't think that this is a realistic proposition. For now, I think what matters more is building coalitions of like-minded countries, jurisdictions, blocs. And here it's all about democracy, rule of law, and a commitment to upholding and safeguarding privacy and data protection in the national legal order. And this is the basis that, to my mind, underlines all the efforts that are being done in the OECD, in the G7 context with the initiative on data free flow with trust, and similar attempts at multinational, multilateral level to define what trust means and with whom can we cooperate more easily than with others.
Thank you very much, Anna. Nico, do you want to comment? Where we chance?
Yeah, maybe let's call it an observation. The EU is incredibly young. Other observation, I don't recall or I don't know, but maybe still, if the United States were not the United States of today, maybe we would have 50 different intelligence agencies. That's not the case. So Europe still has to grow in this, and the trust has to increase. We do have another Europe called the Council of Europe, which is larger than the EU, which has a much more longer tradition to deal with other topics than purely coal and steel. And of course, this is a bit of a cliche, but the Council of Europe has a new convention, Convention 108+, which does deal with national security and defense. That's rather unique because, as to my knowledge, that's the only instrument. And don't forget, the Council of Europe is also known from another convention, which we often refer to, the Budapest Convention on cybercrime. And that seems to work. So from the optimistic side, it's not only problems. We have had these issues before. We were able to solve them, or at least to come closer to each other. So only focusing on the EU to solve all European problems and even transatlantic or transnational problems might be not the first step to take if you want to have some action. And I think that these alternatives that we have used for cybercrime are now developing also in the domain of national security, and that would help to increase trust on the side of industry, on the side of citizens, on the side of institutions in general.
Thank you very much. Locke, did you want to comment?
Happy to. National security is the prerogative of the member states, but I see in digital sovereignty a big willingness to basically hand it over, or they're all looking at Europe to organize stuff that, you know, because they realize that their discretionary powers are actually undermining national security. So I find the level of cooperation and willingness to look at digital sovereignty measures at a central level increasing by the day. You asked about war. I think we're not at war, but I see chair of the Atlantic Council in the Netherlands and in the Cybersecurity Council of the Netherlands, and I see all our intelligence services, the military, everybody is preparing for war. I'm not saying it's coming, it's just that everybody starts to prepare, and that is a different world, and where you start looking in a different world at your dependencies, which is also, I don't know, the possibility of undersea cables being, you know, sabotaged, or, well, we can go on and we get it. And you see that Europe is trying to be more, it's not that they want to be going it alone, but that they want to have alternatives that they can scale up if the necessity is there. So digital sovereignty, yes, and I find actually Microsoft and Amazon, AWS and Google reacting in a proper way by, you know, implementing EU boundaries for data, and not only meaning that the data is hosted here, but that it is serviced here, and that, which is that a privacy thing? No, but it is a reason that you maybe don't need the cables, that you do have the people here to service you if the US is in war with China for other reasons. So anyway, that is, you know, another comment. Yeah.
Thanks, Locke. Do people have questions or comments on Europe as Europe's role in this expanded world of data? Where should this sit? European Commission, Council of Europe, as Nico mentioned. Do you want more concentration of power in the center? Who's thinking about that? I hope someone is. Yes, go ahead, please. Yes. We need a microphone here, please. Hold on, thank you. Two here.
I don't know if this is, I'm Mitra Dominguez from EDRI, European Digital Rights. And sorry, and if I'm thinking about the role of the European Union, and that's also linked to the geopolitical debate that we were having, I also want the European Union to be a protector of fundamental rights and human rights, and that's actually something that the GDPR contains when it comes to the adequacy decisions. And I'm not sure this has been respected as of lately. I'm thinking about a letter that EDRI and other digital rights organizations sent to the European Commission, shedding light of some of the insufficiencies of the renewal of the adequacy decision regarding Israel, concerns that happened well before October the 7th about data retention, about the use of mass surveillance, and also about the use of the onward transfers to the occupied territories, which the European Union stance is that this is also a clear violation of human rights and international law. And I'm wondering if this idea that geopolitical considerations are central, but they are somehow trumping not just human rights concerns, but also data protection as a fundamental right concerns, shouldn't be also central to a debate like this one. Thanks so much.
A very fair point that they should be central. Thank you for that. Let's keep that in perspective.
Could I maybe
Anna, go
quickly
ahead.
react to that? Maybe just by saying that obviously it's the European Commission that is the master of adequacies, and hopefully will take the appropriate steps if appropriate and necessary. But just to say that again, back to the different hopes that we might all try to pin on the GDPR and the actual objectives of the legislation. Data protection regulations, GDPR, and the transfers regime in particular have been for many years accused of being instrumentalized in the interest of digital protectionism or trade protectionism, rightly or wrongly. And I think, some arguments put forward in that letter would take this instrumentalization to another level, and I believe personally that it should be avoided. Thank you.
Thanks, Anna. Let me turn now to Professor Locke Morel for our next question, a next theme to expand. Locke is Professor of Global ICT Law at Tilburg University and Senior Counsel at Morrison Foerster in Brussels. Locke, I wanted to ask you a quite specific question about the ANISA cloud standards and the debate that's going on there. But what I'd like you to do is to take that into an examination of AI. Because we've had a panel now going for 30 minutes, and we've only mentioned AI explicitly once. Yeah. And even though there's a lot of hype, that's clearly not enough. We need to talk more about AI, generative AI, LLMs, and what it's going to mean to the world of data flows as well.
Okay, so AI. Well, I think the realization has set in that a lot of individual companies do not have enough data to train their AI in a proper way. So what happens then is that their data is often in silos in the various clouds of very large providers. And that's where you saw that the Data Act was starting to ask for interoperability between the clouds, data portability, the European data spaces trying to make combined data in order to be able to train AI. So Europe can have a competitive, or at least use the data they generate with their businesses rather than have that in clouds of companies where they cannot be utilized enough. So if you do not realize this element, it's difficult to understand why we have the Data Act where they try to say that companies that generate their data have, a possibility to have that data and things like that. The interoperability requirement starts to make sense. So this whole, if you talk about AI, or if you talk about the laws that have been put in place, it is difficult to understand what they try to achieve if you do not realize that AI is on the horizon and is expected to be, an important element in the business and the possibility to generate money in Europe and our competition position. So, yes, it is, if you don't understand what you need to develop AI, it's difficult to understand European legislation. Is that a good starter of the discussion?
Do you think that's going to be enough to generate AI industry in Europe, those measures? Do you think that's going to work? And then I want to bring in...
Well, the good thing about new innovations is that you can always start anew. There's certain industries that if you combine the data or our health data, and LLMs is a different topic, but there's also all types of other different types of AI, and you can, if you have the data, you can properly train AI. Till now, we have the AI Act, which also applies now to the LLMs. The LLMs are here available. I'm personally involved in a Dutch language model for the Netherlands. We're also involved in, setting up the German language models. The US models are trained on US data. I tell you, you lose the specifics of a language if you don't train it on proper Dutch language or Nordic languages, etc. So is it all lost? No, absolutely not. If you see the amounts of money invested in China and in the US by the combined companies, we're really behind. And but I'm optimistic in nature. I think that they try to, with a lot of IPSI projects and money behind it, to innovate and stimulate that, and the data spaces, etc. Yes, I think the moment to act is now, and I think the Commission is at least trying to not only have new legislation, but also the money to innovate to meet the requirements of the legislation.
May I
Thank you. Well, let's go to Julie, then Anna.
So I thought that was such an interesting and spot-on response. I do think data is going to be an incredibly important element as we are building AI, but it's really important to, I agree with you on that. Full stop. I think it's also important to recognize that that is one input, a very important input, in a technology that actually has different layers to it. And in the absence of some of the other layers, it will be very hard for Europe to accelerate in terms of advancement of an AI industry at the same level that the US now has. And some of those layers, we're definitely trying to help with. You already mentioned the EU data boundary. We do process data inside Europe for our European commercial and public sector customers, and that includes for AI. That is all done within Europe. And so the idea of building AI that is appropriately calibrated for Europe is deeply important. But the other things that you need land, and you need land that you can build data centers on, and you need those data centers to be very carefully monitored and to maintain a lot of security around those data centers. You need GPUs, that is, the right type of chips, and many of them, in order to also build LLMs and other foundational aspects of AI. Now, I'm not saying Europe can't do that, But the level of investment that we're making in Europe in order to make that real is astronomical, and you're seeing the same thing that the other large companies are doing. I think that there are other layers of the stack that are deeply important, and I think at some point Europe will be needing to ask the question, do we want to safeguard the ways in which companies are developing those lower aspects of the stack? They're good, they're trusted, we need to make sure that that maintains, and we need to invest in the upper layers of making sure we do get large language models that are designed for Europe, making sure that the apps that need to rely on those foundational models are able to flourish and develop 1,000 flowers blooming at that user level, both for companies to provide to their customers, but also for individuals. So I think the conversation around Europe succeeding in AI and what Europe needs to do, whether the EU AI Act is enough, whether GDPR, whether the Data Act are inhibitors or accelerators, I think that that's important, but it needs to be, I think, a nuanced conversation about the different layers that need to be approached.
Thanks, Julie. Anna?
Yeah, I just wanted to say thank you, Loke, for bringing in the data spaces into this conversation. I not only agree with everything you said, but I also think that we should increasingly think about data spaces when we discuss the evolution of future data flows. Because for now, there are attempts not only in the EU, but also in other places to create such trusted infrastructures for seamless data sharing between participating entities, to put it very simply. But we already see increasing interest from other jurisdictions, for now those that happen to have adequacy with the EU, so that's reassuring, to collaborate in this space of common data spaces. And so I think that in the very near future, instead of, or in addition to discussing transfers as, data flows as transfers from controller to processor, processor to processor, and all of that, we will actually be talking about shared, trusted data spaces created for different purposes.
Thanks, Anna. You may have noticed, everyone, that we only have 4 of our panel here. Sadly, we lost Chiara Manfredini because she was just a bit poorly. So we've lost Chiara. And I was going to ask her this question, but as she's not here, you 4 are going to have to answer it. And it's about the power of inference from AI. Well, whoever feels confident to answer it, but maybe Julie, because the power of inference. So AI fills in gaps. That's what it does. You take a data set, you apply AI to it, it can infer what ought to be there. That's the actual mechanism. What does that do to our concept of GDPR type privacy and data?
Sorry, I'm trying to understand the question. You mean, look, the model is trained on the data, so then it's not there anymore, and
the model is able to.
How does GDPR work out? Is the output?
I think it's about, is the output personal data, or are you creating something new that is no longer personal because of the way in which there's inference? Can I just jump in on this for 2 seconds?
Go ahead.
So I think there are ways in which some of the outputs are personal, and there are ways in which they are not. I do think you are right that the models that make the system smarter to understand when you are writing a sentence that says, looking forward to seeing you at my birthday, blah, blah, blah. It knows to fill in party, or it knows to fill in whatever. And that's just the crudest of examples that have been around for a long, long time. That kind of knowledge about inference, about human speech, I would say is not personal data. I do think what is personal data, though, is the queries that individuals ask, and that is the prompts that they type in, and the responses that are going to an individual. Now, the response may have personal information in it, may not, but to the extent that you want to link that prompt to an individual, that individual has asked question A and got answer B, and it's all linked to James, that becomes, in the European framework, I believe, personal data. So I think, again, the conversation is a bit nuanced. And what, frankly, a lot of the AI developers are doing, you know, the prompts and responses, you actually don't need to have that personal data attached to it. You don't need to know what the fact that James Arroyo asked question A, B, or C. What we need to know is question A was answered and the response was provided and it was good. It got a thumbs up or it was adequate. It made the grade. So there are ways in which output is personal or input is personal, and there are ways that can be eliminated pretty quickly.
Thanks.
Does that make sense?
That makes sense, and that's an interesting comment about linking the responses to the person. I also meant, let's say you choose to give 3 pieces of information about yourself, and then you have a powerful model which infers another 3 that you didn't, and those 3 are correct. That's it's only interesting if the models work, but then that's what I mean by the creeping change in personal information. You can infer sexual orientation. You can infer political tendency. You've not given that. No one has taken that information from you, but it's inferred correctly. Does that sort of still fit with a world of GDPR which defines kind of personal data as something you give rather than something which is kind of like sketched out about you, which I think is where we're increasingly heading? Anna?
Well, I think, you know, we should not fall into the trap of always thinking that any new technology really creates new problems. And specifically under the GDPR in the context of, and even the old directive in the context of Working Party 29 and EDPB, the question of, you know, inferred data, yes or no, also personal data in other contexts, targeted advertising and et cetera, that has been, and I think it still is being debated to a certain extent. So I would probably personally share your views that in most cases it would be personal data. But as you may know, we are still having very heated discussions, including before the court, the General Court and the Court of Justice, on where exactly to draw the line between personal and non-personal in specific situations. And there are different schools of thought. So unfortunately, in most cases, a DPA answer to this question will probably remain, it depends, and it will be still a case-by-case analysis. I personally belong to the camp, let's call it like this, that believes that it's probably more productive to have a somewhat more limited or less expansive definition of what personal data is to really be able to afford meaningful protections with the GDPR safeguards. But there are also others who claim, no, the broader we go, the broader we cast the net of personal data, the better it is. The outcome
I'm simple. There was an Irish professor, and if you asked for his CV or bio, it said this guy was dismissed from Trinity College because of sexual harassment, and then it gave, you know, a link to an article. He wasn't dismissed, not for that reason. He was still there, and the article was made up. I tell you, any DPA in Europe will say, if you ask for his CV, and this is what you get out, and it is completely wrong, they will consider it within the law, and he will have a right to So my point is, we can have a big debate, but as long as this type of, so the input can be personal data, the output will be personal data, if it is related to a person, obviously. But I hear a lot, and I'm just throwing it out because I hear a lot of developers. Software is not governed by GDPR, but a code is AI, an LLM, is trained on personal data. And, you know, in a lot of cases, if it is fed in many times, if you have a CV of Julie, it will, or information will be fed to it a lot of times. And research shows that it is memorizing that data. So it is not just zeros and ones, it's actually memorizing. And there's a lot of ways to get the data out again. There's data leakage, there is, well, I can go on and on. But to argue that an algorithm, an LLM, is not or doesn't contain personal data is a steep, an uphill fight, if I look at it. So it's not just the prompts, it is the training data, it is the algorithm itself, it is the inputs, it is the outputs. Not always, but it can include personal data, meaning that you need to take into account GDPR, whatever you do. I'm not saying it is with IP addresses, or it's not always personal data, but it is in some, or in many cases, it is, and then you need to take it into account. I just feel the need to say this because I see whole types of discussions about software developers like, oh, this is totally outside the law, and you think, well, let's discuss again.
It sounds like it's all personal. You're thinking? No. Okay, Anna, you wanted to quick comment, then I want to.
And I would just want to add to that. I think, you know, I would also not draw the conclusion, if it is so, we need to reconsider the GDPR and its principles. No, maybe, perhaps, in some cases, we need to think about how to apply. How to apply them in these specific contexts. But again, this is something that has been done before for other new emerging technologies, so I think we are well equipped.
Okay, Nico, you wanted to come in? And if there's a question on AI or comment, then we'll take it. So please think while Nico talks.
I'm actually concurring what Anna said. With new technologies, you always see that everything is considered to be different. And then you have the traditional process of commodification, and that shows that it's not so different. And all of us also suffer from another trauma, and that's the hammer-nail trauma. So if you're in law, everything is a legal issue. If you're in privacy law, everything is a privacy issue. If you're an economist, everything is an economic problem. This is not to make AI less important than it is, because it's a very important development. But there are also coping mechanisms that we sometimes don't see prima facie, but that will develop through the upcoming time. And the best thing to help that is to try to stay away from micro concepts like everything is personal data or everything is GDPR. It's more complex. That's not an issue in the sense that we cannot control it, because we have very strong, in society, strong approaches to developments. Just to name one, product liability. That's a concept we have developed through washing machines, to all kinds of stuff we buy. And product liability is all something that applies to technologically new products. In the beginning, we give a little bit more space because it's innovative, and then gradually we move into treating it the way we treat product liability with other things, because we don't want to do the opposite, to say, oh, you buy a washing machine and now it's your responsibility whether the thing works or whether it doesn't work or how it is made or whatsoever. But it takes time.
Thank you. Any questions, comments on AI before we move on?
Well, I would like to make one more comment. That it is in sometimes, governed by GDPR doesn't make it then that you apply it in all the elements in the strictest way. Then you need to rethink what the principles are, and whether, does it mean then that you need to have an opt-out to be included in training data, or maybe individual rights are better served if you can, like this guy, this professor, can complain about the incorrect answer, and you do a safeguard in it, that it doesn't pop up anymore. My point is, and there I totally with you is think it through again from the principles and then try to apply it in a new world rather than say, so we need to have data subject rights and access to the training data. If you think about how many John Smiths there are or whatever, is maybe not useful, not beneficial, it doesn't add. Do you see? And I'm not there or there. It's just keep an open mind and don't close it down so much if you want to innovate and think through what the real principles are and how you can serve them best, with also the interest of, you know, the possibilities of the new technology.
Thank you very much. Yes, please, go ahead. We need a microphone here. Thanks.
Thanks very much. This is Ben Avison from RAID, which is the conference about the regulation of AI, internet and data. And there was a comment made in a panel earlier today about whether the AI Act's risk-based approach was sort of exportable as a sort of a philosophy in the way that GDPR was. Will the Brussels effect apply to the AI Act? I'm interested to hear what this panel thinks about that issue in relation. I guess it's related to the question of data sharing.
I could give my view first, which is no, but others may have different views.
That's interesting. I would say yes. And the reason I would say, I mean, it's not de jure exportable in the sense that there is no adequacy determination inside the EU AI Act. GDPR became exportable because every other jurisdiction was saying, gee, we do want to interact with Europe. We do want to have data flows. We better figure out how we do that. And frankly, the Commission assisted. It wasn't just adequacy. It was standard contractual clauses. There were a lot of ways in which we could engage with data flows under GDPR. But there were requirements. And that was what made the concepts exportable. I think in the EU AI Act, there is no requirement that other jurisdictions have the same approach, but it is in practice becoming exportable. I think what we're seeing is a deep convergence in the UK, in Europe, in the United States. Japan is driving this too in terms of the G7, and Korea actually just a couple of days ago, I think there was an agreement where you are seeing a consensus being built around what the fundamental approaches to regulating AI ought to be. And there is a very, very strong theme of taking a risk-based approach. So I mean, on some level, you are right. It's not going to be required under the EU AI Act in the way that GDPR, I think, very cleverly ensured that the rest of the world would meet or try to meet the standards in terms of privacy. But I think it's actually what we're seeing is a convergence because of the need based upon the underlying technology. And so the governments of the world and civil society, and frankly, the companies that are involved. I mean, we're not the only one, but Microsoft is deeply supportive of all of these efforts. Yeah. But again, we're not the only one, because we understand that the technology needs to be trusted, and the technology needs to be embraced. And the way that's going to happen is by, I'll say, exporting these concepts around a risk-based approach.
Anna?
I would entirely agree if you speak about risk-based approach in general. I think that has been, by the way, you know, that did not emerge with the proposal for the AI Act. There were years and years of discussions and research before, so I think there is indeed consensus internationally that this is the right frame to look at AI. But if you mean specifically that, you know, this risk-based approach, should that mean that a jurisdiction would decide that certain uses or applications are too risky and should be banned? That, I think, is probably more complicated, and I would expect much more difficult discussions, and frankly, I do not expect some jurisdictions to ever go near a ban for even the highest risk applications. I think there were some discussions in the framework of the Council of Europe Convention on AI, and there wasn't a consensus that anything should be properly banned. So let's say risk-based in this narrow sense of arriving at outlawing certain uses or applications is probably much more problematic.
Yeah, I said no, really thinking about the geopolitical situation. I think risk-based is a bit of a cheat because it's sort of like, of course, if we're going to examine risks, everyone's going to try and examine risks, but you can have a radically different view of what the risk ought to be examined against. And I think that comes to where you think about the geopolitics. And that's where I want to take us next with our final speaker, with Nico van Eyck, who has just stepped down as the chair of the Dutch Review Committee on the Intelligence and Security Services, and is a professor of information law at the University of Amsterdam. So, Nico, to kick off this final geopolitical discussion, I mean, the context is changing a lot. There's the geopolitical angle, there's also increasing cybercrime risks and broader organized crime risks. How do you see these trends shaping our attitudes, society's attitudes, government's attitudes towards data access?
Thank you. I will mainly focus on the national security element because that's...
Nico, just I found you really do have to hold it close to get these mics to work.
In your introduction, you started also by mentioning the situation in Ukraine. And not to really make that an example, but it does show how important data is. In a situation of warfare, you have a constant need to get updated and to get information about what is actually happening. But at the same time, data are also used as a strategy or well, earlier it was mentioned, is there a cyber war? But they are part of a strategy. And from a national security perspective, you see basically two dominant strategies. One strategy is aimed at destabilizing economies. That's the craft of stealing business secrets. That's the craft of hacking into government or in companies and stop them from doing their usual work. The second angle is the angle of destabilization of the rule of law, of democracy. That's where we use terms like disinformation, misinformation, but those are two very important strategies you can use to get control over a conflict or to influence a conflict. In that context, I will have three observations. So the first one is, and I'm happy that in this debate we more use the term data instead of personal data, because it becomes more and more complicated to predefine whether something is personal data or other data, because data is not presented that way. Particularly in a national security context, you're talking more and more about bulk collecting of data, because that's the only way data is being stored and being collected. It's not like that an individual set of data of an individual person is being collected. It's always part of much larger entities of data. And now coming back to the point of risk harm. And the harm is something you cannot define beforehand, because it's all about how you are going to process data, what kind of data you have. Is this personal data? Is it other data? So labeling of data is becoming more and more complex. A second observation is, when you talk about national security, that national security is basically a contradiction in terms. Because there is typical national security when it comes to national conflicts, but all the real issues that we are concerned about are without borders. It means that you need to have international cooperation. This is where there is the standard cooperation between security agencies, But there is more and more involvement also needed from society, because the data that are relevant in the context of national security, and I'm only talking about legitimate aims, so where society has decided this is what we allow in the context of national security. It's more and more the whole mix of whatever there is available. So it's not only government information or information gathered by intelligence agencies, which is extremely costly. Making your own data is a very costly activity besides what you do with your iPhone. Therefore, more and more private data or privately gathered data is relevant in the context of national security. Simple things that we all know of is, for example, when there are cyber attacks. They happen everywhere. Some of them are a threat to national security, some are private threats, some are a combination of those. And then the big question is, which data do you share with whom? Because who is a trusted party? The fact that a company was originally working within one particular country and then for business reasons moved to another country doesn't automatically mean that then the company becomes an organization you can work with. Very complex matters are at stake at this moment, and their trust is a very important thing. Thirdly, things go incredibly fast. And particularly in law, we have big issues with dealing with that. So a traditional example we have been facing with is if you have a target on the internet and you know where he is, and it's a requirement in order to get a warrant that you have to indicate where a target is on the internet, you need to be aware of the fact that by the time you get there, he has moved away. Or when you're there, he instantly moves to another spot. How to deal with that? Are we going to give blanket licenses? Probably not, blanket wars. But how to deal with that? That was one of the discussions we had in the last years in the Dutch context. That's the context I know more of. And that's where it took a very serious public debate, but where we decided that if you want to create more flexibility, you need to compensate that. And that's where more flexibility to develop better understanding of the unknown is compensated by more real-time oversight. So it's looking into checks and balances and leaving very static ideas as everything is predictable and you can put it in the law at a very detailed level. And that brings me also back to the earlier discussion about risk harm. There's a difference between thinking that you know what risk harm is and putting all the details of risk harm in positive legislation, or to say risk harm is our point of departure and we have these and these and these indicators that we use and we will regularly evaluate these indicators. That creates flexibility, and that flexibility is unfortunately necessary because you're in a situation where you have opponents who are not bound by the same limitations, and you still want to remain within the rule of law. So we are in desperate need for alternative regulatory interventions, alternative ways of looking how to keep a check and balances, how to do that within a risk-harm approach without going back or continuing extremely detailed legislation, because that has turned out to be a dead-end story.
That sounds quite labor-intensive.
And then to translate that into geopolitical solutions, so that's interesting to do. But we can do it because we have done it before in other domains. Because that's where, again, hammer-nail comes in. Too often we see everything as a privacy problem and we forget, take for example my background, oversight, that we have similar developments in financial markets, in economic markets where there are high uncertainties. There is no country almost in the world anymore is even forbidden on the European rules to say you have a dominant market share if you have a market percentage of 54% or 20% or 30%. we have a risk-harm approach. We indicate what are the factors
Yeah.
we look at, and then we assess whether those apply in a particular situation.
Thanks, Nico. You explained that I think well, and that challenge of like fine judgments, but high frequency. Yeah, I'll take one quick comment, and then I want to see if we have any final questions, because we're up against the time.
I just wanted to say that I think the Commission found a good, or Europe found in the AI Act a good middle ground there, and that's why I think it will reflect or have its reflex working in other parts of the world. Is that, remember, in one of the stages, the Parliament has a whole list of requirements for LLMs. And then there was a debate, the Council said, oh no, we need the Commission to make a implementing act on all the requirements for the LLMs. And where did it end? Is that they said, look, the participants, you know, the developers need to make a code of practice, and they need to submit it or discuss it or negotiate it with the AI office, and then based on rounds of discussions, probably in the end ENISA will be tasked to set standards. I thought it was brilliant, because when you start setting the requirements for an immature technology, you're, you know, fixating an immature technology. It is by asking the companies, what can you do, feedback, it is the learning feed loops. And once they agreed on a proper code of practice, of course you're going to do it in the rest of the world. I mean, you know, what is your code of practice? That is then what it is. So this is the way they now decided to do it. And I think that is a very clever way of flexible legislation if you're in a time of disruption and innovation.
Thank you. Does anyone have a final question on something we haven't covered or on things we have? Please, got a microphone here, please. The young woman here, thank you very much.
Thank you for the interesting debate, first of all. I have a comment vis-a-vis what you were discussing about the applicability of the AI Act beyond borders. And I would say it would apply. So I'm a lawyer, first of all. My name is Petruța Pirvan. I am a consultant in data privacy. And I think the AI Act comprises a legal provision which will make it applicable beyond border, in the sense that it is extraterritorial, like GDPR is. So deployers, providers of AI systems will have to comply with the requirements of the legislation. My question is the AI Act, in your perception, a product safety regulation or a fundamental rights protection framework, or a hybrid? It's very important for the internal governance in the companies, but also for the offerings in the market.
Thanks very much. That's a great question to end on. Julie?
Yeah, I can take, I'm sure Anna has thoughts. I'm sure actually everybody has thoughts about this. So first of all, of course, you're right that there's extraterritorial jurisdiction. That's true with many, many laws around the world. That is different than I think what we were discussing, just to make sure. We were talking about, will other jurisdictions have to enact similar laws in order to allow data to be to flow between the two jurisdictions. So yes, absolutely, EU AI Act is jurisdictional, as you are correctly pointing out. I think the evolution, to your question, I think the evolution of the EU AI Act was super interesting. Over the years, of course, it started out as a product liability law. It really was grounded in those principles. And I think over time, it brought in elements of fundamental rights, for instance, some of the requirements around facial recognition, just as one of several examples. So I would say it's a hybrid, and I think that happened over time, over the debate through the few years that it was under discussion.
Anna?
Yeah, full agreement. I mean, it was already, obviously, these hybrid elements were already in the proposal. So it was never purely a product safety instrument, but it was strengthened. The fundamental rights protections were definitely strengthened throughout the legislative process. Now, the question that I am asking myself is how it will work out in practice. So aside from the very simple cases where there would be, deployment or use of an AI system against one of the prohibitions, that should be relatively easily enforceable. But bottom line to me is that the structure and the mechanisms, the self-certification, self-reporting, the requirements are in large part better suited for a product safety instrument, while it now comprises much more in terms of compliance with fundamental rights and how to make that, and also reliance on the standards. So we will have a huge challenge. We are all in front of the huge challenge, how to operationalize fundamental rights safeguards in technical standards. That has never been a very easy thing to do. We know from even some data protection related information security discussions. So this is going to be one of the major challenges, because precisely the final version strengthens the provisions, the protections for fundamental rights. Thank you.
Thank you. Locke and Nico, any comments on how the AI Act might work out?
I'm not an AI expert, but I've read it, and like the GDPR, it's mainly about the exploitation rights and the limitations to the exploitation rights, and those limitations also include fundamental rights. So it's a hybrid instrument, like almost all instruments, because law is always based on principles and fundamental rights, because otherwise the law would be an infringement of fundamental rights.
It's now explicitly included. For high risk, you need to do a human rights impact assessment. So how that will pan out, that we will see with all the cases going up or being looked at by the DPAs or the AI authority, competent. Well, in the Netherlands and Spain, it is the same authority, which I think is a bad idea. But anyway. No fundamental right is absolute, so it is always, a balancing. But yeah, it is included as one of the elements that you really need to look at. And GDPR still applies as well, so which is also fundamental right.
Thank you very much. Well, look, I thank you very much for staying with us. I think we've established that the data landscape is complex and evolving. We haven't necessarily solved everything. But please join with me in thanking our panelists for a fascinating conversation.